Get a lot of information on our website, but I think it'll be really good to add on to that and just really dig in deep with some of these situations that happen.
Yeah.
I think we should start out with what probate is, because I still don't think people really understand what it is.
Probate's not legally required. A lot of times practically you wind up having to. Some of the big reasons you might have to go through probate is if there's real estate involved. There's not too many ways to transfer real estate out of the name of a deceased person without going through the process. So when we think about this process and why it exists, right? Because it's a hassle. Nobody likes it. Nobody likes having to go through a legal process, right? Something we hear all the time in the office is, this should be easier. Why isn't this easier? And that's interesting because, frankly, because of people and because of fraud. If you take a group of folks that is totally honest, totally upfront, and just wants to do the right thing, and these are what the rules are, and we're just going to follow them, it would be easy. Yeah. But that's not reality, unfortunately.
Yeah.
And so we have a process that has checks and balances. So without a will, you've got different folks you're concerned about in every probate case. You've got the person who's going to be in charge and responsible. We call that person an administrator without a will. Okay. If there is a will, we call them an executor. Yeah. Then you have the folks who are going to wind up with the stuff at the end of the day. If there's no will, we call them heirs. If there is a will, we call them beneficiaries. Well, without a will, our administrator is chosen by a state law process, basically a voting process. And our heirs are identified in the statutes themselves. Okay. And so there's no choice.
So what happens then if, let's say, I create a will and I have what I want, put in my will and everything, and I even tell the people I'm going to leave everything to, hey, this is what I'm leaving you. I want you to know that ahead of time, this is what it is. But then we flash forward a few years and something happens to me, I pass away, and someone else has been around me, maybe a little closer, and now those terms have changed, and everyone's looking like, well, wait, Jenny told me that I was supposed to receive X, Y, and Z, but her will says something different. What would you say to those people at that time?
Yeah, that's an awful situation, right? So in your scenario, the will got formally changed. It wasn't...
At some point, yeah.
It wasn't just, let me scribble this out.
Yes.
Like I made a will.
Yeah.
Unfortunately, if that will is valid, it can be valid, and this could be one of those scenarios where we get an unfortunate result. But there's hope, and the reason that there's hope is and again we go back to the process, right? We started this conversation on why do we have a probate process. Well, your scenario you've given me is a great answer to that question, because without a process, if we go back to the strongest is going to inherit everything, right? Well, that person that got the will changed, the kind of the deathbed will change scenario, that's great for them, right? Yeah. They wound up getting everything. They kind of screwed the rest of their family. Mission accomplished. Yeah. But we have a process.
Well, that makes sense. It does. And like I said earlier, it's an emotional situation for a lot of people. I think that's what, people, when they're arguing over an estate, can forget that it's not just emotional for this person, but it's emotional for this person as well. Everyone lost somebody in that situation. And so we see it a lot. And I remember speaking with him after, and he was saying that was the biggest, regardless of the money, regardless of the property, all that, it was, he needed that to let go of other things. Yeah. And had he not went through this process to stand up for himself for once, because he felt like he never stood up for himself any other time, had he not done that, then that letter would have never came. Yeah. And if that letter didn't come, then he didn't get that closure, at the end of the day, which I think is another thing that a lot of people are looking for, is really that closure. And would you say that?
I think so. Yeah, I think it's pretty uncommon. It's allowable.
Yeah.
The court will accept your will. You can go down to the courthouse. I'm sure they're going to charge you a filing fee, and you can file your will of record on the county books, of the probate court books. And then when you pass, it's there. The benefit of that, I think, is fairly obvious. Nobody can mess around with the will. Pages can't go missing. Yeah. The document itself can't get accidentally burned in a fire. Those kind of probate stories we hear.
Yeah.
Right. I swear there was a will.
Yeah. Exactly.
But I think my cousin found it. Now there's no will. Right.
Yep. Well, I guess, but then on the other side of that, though, is if you wanted to update it, you'd have to take it back and then file another one. I think that's why probably people don't do it as often. That's it's in my mind. We get asked that a lot on the front end. Well, what isn't it at the court? And it's something that our team definitely checks all the time to contact the court to see if anything's been filed or if the will is there. But from what I've seen, most of the time it's not there.